Thank you very much. It's too much, of course. So thank you, José Antonio, Ayan, and Yannick for your very kind invitation. This is the best moment because there is an evening after, perhaps some drinks, so I will be short. I had a very pleasant journey, day, listening to very much expertise, lot of thinking. It was a kind of a brainwashing, very, very deep and interesting and opening new path. Ladies and gentlemen, the best available science establishes that climate change poses an existential threat. So some are not convinced of that, but most people driven by reason are. In this context, this conference, which we must be grateful to hold here in the Netherlands with open windows for some fresh air, and not in New Delhi, where the daily temperature is 48 degrees, has made one thing clear. The advisory opinions on climate change cannot be ignored and are now driving change. So I must disclose that I was involved in the action toward the advisory opinion of the ITLOS on climate change. I did write the questions, and I was involved also in the advisory opinion of the ICJ on climate change, but only as a counsel for one state. Of course, advisory opinions are not compulsory. They are addressed to those which put the questions. It follows that the ICJ advisory opinions, based on the request from the United Nations General Assembly, are addressed to the UNGA, which may or may not take the opinion delivered by the court into account. In our case, the UNGA has backed the advisory opinion in a resolution rejected by only 8 states, which is not a lot. Among these states, the United States of America explained why it rejected the resolution. I quote the explanation of vote of the United States, or part of it. The court's advisory opinion is, by definition, not binding on UN member states. It was not issued in a contentious case between states on the basis of state consent, but rather pursuant to the court's advisory function. Yet, the resolution improperly treats the court's opinions are irrefutably authoritative and as setting out binding obligations on states, end quote. Well, this is a profound misunderstanding. The advisory opinion does not pretend to set out binding obligation. It clarifies the law, and what is binding is the law. It can be disappointing for those in the United States that would like the state and the United States to join the Paris Agreement. The US Senate would have to be involved and would likely refuse, but the US is not party to the UNCLOS. But at the same time, it always said that it respects UNCLOS provisions. It even declared an extended continental shelf, as if a party to the UNCLOS. So I suppose that the United States could also decide again to respect the core obligations set out in the Paris Agreement without becoming a party. Because indeed there are substantive obligations. The advisory opinions of the ICJ, ITLOS, and the Inter-American Court have clarified that climate obligations do not pertain to the sole realm of political aspirations, are not left to pure discretion of states, but are truly binding. And this was not so obvious. I heard that everybody was convinced of that. I remember the discussion at the Institut de Droit International, where very prominent friends were saying that no, it cannot be obligation because, you know, states know better what to do. They know what they can do, and they will do what they must without being bound. Well, no, they are truly binding obligations. There is, of course, no question here of strict liability for emitting greenhouse gases, but clear obligations of conduct submit to a standard of stringent due diligence. Due diligence, when it comes to reducing emissions of greenhouse gases or finding another way to reduce the greenhouse gases in the atmosphere, if it does exist, and perhaps it will, is not a vague concept, but a demanding standard of conduct informed by the best available science and the foreseeability of cumulative harm. So are there customary law obligations? Well, this is what the ICJ said. Should we doubt of what the ICJ said in this regard because some states are unhappy or because we don't believe in what the ICJ said or on its reasoning? I know one case where, perhaps there are others, but there is one I know where states specifically adopted treaties to contradict a statement regarding customary international law. It was the Lotus case. In this case, the PCRJ stated that Turkey had jurisdiction to prosecute the French officer on watch during a collision occurred in the IC between a French boat and a Turkish boat. And states were very upset because the collision occurred in the IC. And in the IC, normally, only the flag state has jurisdiction according to states to sue anyone on boat. So the states upset adopted the 1952 Brussels Collision Convention, stating a completely different rule. It was repeated, this completely different rule, in 1958 and in 1982 conventions, and now it's customary international law corresponding to what state wants. Needless to say that for now there is no convention overruling the ICJ finding in the advisory opinion on climate change. So, international climate law has been clarified, both on the conventional level and on the customary international level. But of course, the role of international in coping with the problem of climate change is limited. This is what has been said at the beginning of our discussion. Sometimes recalling the law puts an end to the debate. Sometimes it is only bringing elements to try to find a solution to the debate. Think, for example, this powerful tool for resolving dispute, and someone talked about it today, which is conciliation. You can speak about mediation as well. International law can be used in this process, but it's not the end of the story. It's an element of it. Yet, the clarification brought by the advisory opinion affects how we approach investment arbitration, which is the very topic of today. How could not arbitrators ignore, if relevant, states' obligation to combat climate change when assessing whether their measures are lawful? The state's measures are lawful. And of course, a lot have been said about this today. Of course, investment treaties should not be interpreted in clinical isolation, even if they have been too often been so, despite Article 31(3)(c) of the Vienna Convention on the Law of Treaties. This was a big part of the discussion. By the way, the ICJ has added some elements to the discussion some days ago in its advisory opinion on the right to strike, to the long debate regarding the meaning of Article 31(3)(c) of the Vienna Convention. The court said, and I quote at paragraph 90 of its advisory opinion, pursuant to the customary rule reflected in Article 31, paragraph 3(c) of the Vienna Convention on the Law of Treaties, quote, any relevant rules of international law applicable in the relations between the parties, end quote, shall be taken into account when interpreting a treaty. In the view of the court, Article 31, paragraph 3(c) does not necessarily require all parties to the treaty under interpretation to be bound by the relevant rules of international law in order for those rules to be taken into account. A rule may be applicable in the relations between the parties if it expresses their common understanding regarding certain provisions of the treaty under interpretation. Through systemic interpretation or integration under Article 31(3)(c) of the Vienna Convention on the Law of Treaties, both conventional and customary international rules regarding climate change can enter the interpretive mainstream. In other words, and this is, I think, the consensus of today, tribunals are expected to read investment protections, particularly fair and equitable treatment and the protection against expropriation, in light of these obligations when relevant, of course. That does not mean that the protection of investment should be purely and simply set aside as soon as an argument is made by a state based on its climate change obligations. We all know that some arguments are pretextual to hide a discrimination, arbitrary decision, and so on. This is sometimes a strategy to argue something which has nothing to bear with reality. It also does not mean that we should sacrifice energy security for decarbonization. In this regard, investment law retains an essential function, providing the legal certainty and risk protection necessary for the massive capital reallocation required by the energy transition. Without such protection, as I understand is the thinking, we might come back to the old time of the gunboat diplomacy. And indeed, we are in an era where gunboat diplomacy enjoys a resurgence in popularity. And from Colombia, you can see it more clearly than from the Netherlands. I note that the work done in Colombia with the conference on the transitioning away from fossil fuels, which was evoked this morning quite quickly, I think, is exactly about finding the right balance and roadmap. I did read the work done there. And if you read the reports published after the conference, you will see that a lot of work has been done, but the path towards the solutions is very, very, very complicated. Looking at that, you can think, well, too complicated. But I think that if no one begins to seriously think of where to go and how to go, we will never have any credible plan. As of now, regarding investment arbitration, the practical consequences of climate obligations are precise by the ICJ, seems to be significant. So is it the case, and there was the first substantial panel, if I may say, all panels were substantial, but the first panel really dedicated to arbitration. Is it the case when it comes to jurisdictional aspects of investor-state arbitration? And I think that the structure of the conference was very, very understandable in following, indeed, this logic of beginning with jurisdiction, then going to the merits, and then going to reparation and other kinds of solutions. Jurisdictional aspects. So it might be the case when it comes to the assessment of whether an investment has been made in accordance with the domestic law of the state. And here we heard some creative arguments concerning non-disputing parties, interventions. Some new developments show that arbitrators could be convinced to accept interventions from NGOs, experts on climate science. So the case I've read limits the intervention to 30 pages, precising letter size, double space, Time New Roman, font, point 12, so they don't want too much. And it's limited to discussing the climate science and the international environment laws and standards that were in place in the time leading up to AET's investment. So it's really a focused opening to non-disputing parties, additional pleading, just to the extent that the tribunal thinks that it could really be helpful for its deliberation. What about counterclaims? Are they more likely to be accepted at the jurisdictional phase? As I understand it, it was not ruled out by panelists, depending on the treaty language. And when it comes to investor-state arbitration, a lot passes through treaty language, as we know. Now, on the merits phase, it's another question. So what substantive impact will have the advisory opinions on energy and mining disputes? Here, the reflection we have heard have often been based on the, as far as understood, have been often based on the hypothesis of a state implementing its climate change obligation in good faith, which is, of course, to be ascertained in all particular cases. This being said, it follows from the advisory opinions that legitimate expectations of investors can no longer be frozen in a regulatory landscape that ignores the evolving scientific knowledge and legal imperative of decarbonization. Legitimate expectation is, of course, one of the big themes of today. What does it come when it's related to climate obligations? Also, proportionate and non-discriminatory and science-based climate measures now may benefit from a stronger presumption of legality, again, to the extent that the state at stake acts in good faith. So many other fascinating aspects of our question have been raised today, among them the case of a state taking measures consistent with a climate-related obligation owed to the entire international community as a whole. And the question which was put, but I'm not sure an answer was given, and I think it opens the door to a reflection, is can an arbitral tribunal deal with such measure owed to, to respect an obligation owed to the international community as a whole, in the same way it would do with the classical police power measures? Interesting question. When it comes to state defenses and counterclaims, in particular cases, it is all about strategies, tactics, approaches to reduce liability or indeed for elaborating counterclaims. For now, it's all about, as I understand it, creative legal arguments by talented lawyers. The next conference, I suppose, will bring fresh news on how tribunals deal with these arguments. So the last major theme that has been discussed today is in relation to causation, risk, allocation, responsibility in investor-state dispute. And we enter very technical questions, of course, damage assessments. Here, what I understand is that tribunal will probably face increasingly sophisticated questions, but they like that. What part of the loss is truly attributable to the challenged state measure? What part reflects the broader inevitable transition risks that markets, technology, and societies are already internalizing? Distinguishing regulatory risk from transition risk might become one of the central intellectual and evidentiary challenges of our time. Many things, so I think that the opinions open wider the door to a more balanced relationship between investors and states. We are moving towards greater recognition of investors' obligations. And I understand that the carve-out solution to try to protect states from investors when they claim that they have been affected by a climate change-related measure do not work very well. And so we have to rethink or to work on better wording on investment conventions. So the path forward to find the better solution for all the community will likely combine several elements: continued evolution in arbitral jurisprudence, more sophisticated economic and scientific expert evidence, selective treaty reforms or joint interpretation, and greater transparency. It also requires constructive dialogue between communities that have sometimes spoken past each other: investment lawyers, climate lawyers, economists, scientists, and policymakers, and perhaps international public lawyers. And then there is the other problem that was not discussed today, which is the problem of the contracts. Because the shift now goes to contracts, and in the contracts it's quite easy to negotiate a stabilization clause. And if you have a stabilization clause, it becomes more complicated to find a way out for a state when the state wants to change the law. Of course, the advisory opinions do not mark the end of investor-state arbitration, nor do they provide a blank check for unregulated state actions. They mark instead a, hopefully, maturation of the system. They call on all actors, states, investors, tribunals, counsel, professors, to assume their responsibilities in an era defined by profound structural changes. And it comes back to your introduction, Yannick, when you quoted the RCJ advisor opinion, the last paragraph. So I close the circle with this. Thank you very much.
Well, And next, no, there's no next. I thank you, Professor Thouvenin, for your remarks and your thoughtful conclusions. Yeah, my thinking is there's quite a bit of work to be done, and a lot of learning between communities of thought within public international law and also those others that provide key work for public international lawyers and also for arbitration lawyers like quantum experts and many others. With that, I would really like to thank every one of you because you've been here the whole day, copiously thinking, providing your thoughts in your remarks, preparation, and I would like to thank Ian Laird, co-founder, and also Yannick Hadi, and as well as Reza Efgar, and everyone who was here, also the sponsors, the PCA, and those that made the trip, some from Latin America, some from many other countries, and the idea is to keep on this conversation. As some news, we may be working on some type of memories publication. It's not a promise, but it's a might, so that the legitimate expectations are measured, to say the least. And I will leave it at that. We're already thinking about the third wow, The Hague, but I think that this topic has so much more to explore. As Professor Thouvenin said it, we did not look into contract investment claims, which is another world. Yet investment treaty claims will not go away. There's 2,800 or more treaties in force, which even if some states denounce their treaties, will still be alive and kicking for 15, 20 years more. So in any event, thank you. Really, I mean, I would like to give a round of applause to all of you, and it was a pleasure. Now we're going into a little bit of aperitif, and then we'll close. So thank you.